the Supreme Court or the Parliament, where we get the notion that till what extent the Parliament can amend the Constitution, and this is where the basic structure doctrine started evolving from Sajjan Singh to A.K. Gopalan to Kishore Bharti to Maneka Gandhi. So, this with all this background, we will discuss the topic, the amendment procedure. To discuss the topic, we have with us today Ashish Verma, sir. So many of you already know him. He is our professor and it will be Department of Law and Social Sciences. To many of us, he has taught constitution, interpretation of statute, students. So you all know him very well. So without wasting much time, I will request Ashish sir uh, to give away his lecture or to start the discussion. So over to you.
Can you please share in 2 minutes what all has already been discussed?
Yes, sir. So we started with the very first session where we discussed about the introduction to the Constitution, where we discussed about what is Constitution, what is constitutional governance, what were the historical background to it, Constituent Assembly, its features, and in second lecture we discussed the concepts which are enshrined in the preamble, like the constitutionalism, sovereignty, socialism, secularism, democracy, fraternity. So all the ideas we discussed. Then so we have discussed the treasury of the union, the citizenship, Article 12 and 13, the law, the doctrine of eclipsability. And then we discussed, we came into fundamental rights. So in fundamental rights, there are parts, part 1, part 2, part 3. So in part 1, we discussed the golden triangle. In part 2, we discussed the right against exploitation, religion, culture, and education. Right 3 is pending, which is writ petition. So it was due to exam, it has got postponed and we will conduct it later. Yesterday we discussed about the union, where we discussed the president, parliament, vice president, what are the ordinances, what are the power with the council of ministry and all.
Ashish sir, I think Gautam have lost his connection.
But I think he has completed his part.
Yes,
Was he not audible?
So I'll now begin. Thank you, Gautam. And thank you, Ashutosh. Before beginning, I just need to mention one thing, that somehow I focus more on that tussle between legislature and judiciary rather than focusing solely on the amending power of the constitution. So that is also included, but there are few things in it, and I have a presentation which I'll share here. Are the slides visible?
it is not visible now. Yes, sir, it's visible now.
Okay, thank you. When I started making the slides, I avoided using the word tussle, but in fact it was all focusing so much on tussle that I had to use the word somewhere in some of the slides. Whether it's a tussle or not, that can be concluded only at the end of the discussion. So means beginning it with the conclusion would not be very proper. It may sound that there is a tug of war between legislature and judiciary, and it may sound like it's in fact some cooperative functioning of the different organs. So when we talk of legislature and judiciary, so one part is legislature, the other part is judiciary. Legislature means, I should come to the second slide. Legislature means the president, the house of the people, and the council of the states. Because we are focusing more on the central aspect, I have not mentioned the state legislature. But when it comes to a tussle with the judiciary, legislature and executive are to be construed as one, because executive comes out of the legislature, maybe because of the mandate in Article 75 clause that the government shall be accountable to the house of the people and it shall hold majority in it, etc., etc. So it has to come out from the house of the people. But that is not the sole thing of it. In fact, the comparison that we are drawing here, in view of that, legislature and executive become the very same. Executive means nothing other than the majority in the House of Legislature. As and when the government loses majority, it is no more an executive to continue. So for that purpose, it will be considered as a duo, legislature plus executive. Judiciary, as is very evident, it is the Supreme Court, the High Courts, and the subordinate courts. But for the present purpose, subordinate courts have got no space because we are discussing about the direct conflict. So the judgments will come basically on the interpretation of some laws, interpretation of constitution or interpretation of some laws, and focusing on constitutional amendments. So which are giving it a sense of only central or union organs, and plus the other thing is judiciary will be definitely the higher judiciary. I think we are clear on this much of structural comparison so that we can understand what we are comparing with. If there is to be no tussle, if there are organs which are exercising jurisdictions over the same sphere, there will be tussles. So how to avoid tussle? Either one organ should be subordinate to the other, then there will be primarily no tussle. One organ is bound to obey the other. It's a hierarchical structure. Or there should be jurisdiction defined, jurisdiction excluded. You will operate in this domain and the other party will operate in that domain. That will also exclude them so as to avoid any conflict. But that is not solely possible. For that, so far as the territory of jurisdiction or subject matter of jurisdiction is there, it cannot be exactly excluded. But there is something called separation of powers. Separation of powers was a doctrine propounded with some purpose. Purpose was to avoid corruption. Concentration of power was leading to corruption. Absolute power leads to absolute corruption. So it was thought that it should be separated. And what has been the ground of tussle? Why? What subject matter of tussle? Why they have engaged into tussle? Is it that they wanted to use resources for their own choice? I think not. So whether separation or not, first we should come to understand what exactly is laid down in the doctrine of separation of powers. There may be some angles of corruption or possible corruption, or maybe possible, say, egotism, like who has more powers, but separation or not will justify something in this context. There are three basic postulates of it. There should be separate organs, and no single member, no single person should be a member of more than one organ. The three organs are legislature, executive, and judicial. No single member has to be, uh, no single person has to be member of more than one limb of the state. Here, for the present purpose, if we think, we'll have to consider that the legislature and executive are one. So no single person should have membership in both, say, legislature and legislature plus executive and judiciary. If we separate legislature and executive, the discussion on separation of powers will get deviated, and we'll be discussing only on how come it is that all the members of executive are coming from the legislature only. So there is apparently no separation, or at least the balance will lean substantially in favor of there being no separation. So the debate will get deviated. Here we have club legislature and executive, and the other part is judiciary. No person should be member of more than one limb out of these two, because we have made it two. Second is, all the limbs of state should function independently in their domain. They should do their work. Their work is predetermined. Third is, none of them should interfere, means willfully interfere, into the functioning of any other organ. So, is it that judiciary ever willfully interferes or not? Is it that some person is member of more than one or not? Is it that their exclusive domains are identified or identifiable or not? These things will matter in determining whether there is separation or not. In the directive principles of the state policy, Article 50 speaks on the separation of judiciary from the executive. That may be because, if not separated, executive, which is the power organ, may exercise power over or exercise influence over the judiciary, which may not be very good towards impartial judgment and independence of the judiciary. Maybe that This is the purpose. There are other provisions also, like I think Article 122, which says that there shall not be discussion on the conduct of a judge except when the procedure for his or her removal is in the House. So House will not discuss the conduct of the judge in person unless there is a procedure on for the removal of that judge. So that also does not happen. That means the spirit of separation seems to be there. Primarily, it seems that there is some degree of separation done or intended to have been done. Whether this doctrine is applied in India or not, maybe a matter of long discussion. But I'll simply cite something. If we separate legislature and executive, it will be difficult to confine it to our purpose. So, one person, president is one person. Say one person who becomes the president is member of is essential part of legislature. President's office is part of parliament. Article 79 says uh, there shall be a parliament for the Union of India which shall comprise of two houses, namely which shall comprise of the president and two houses, namely to be so and so. So president is part of parliament. President is head of executive. But because they are combined, president has got no membership in the judiciary. However, president is the appointing authority of the judiciary. So constitutionally, literally, president is the appointing authority of the judiciary. This means this spirit of separation is somehow getting interrupted. They function within their domain, no doubt. But is there any interference? One may construe it like interference in the appointment of judges, in the removal of judges, everywhere. Yes, students can use the chat box for asking questions, seeking clarifications, or making additions. Ours is a system based more on checks and balances. Means checks and balances is a doctrine which is advanced, more advanced as compared to the separation of power. Whether post-retirement jobs are violative of Article 50. So far as constitutional provisions are concerned, they're prohibited. Post-retirement jobs are, practice is prohibited. And so far as jobs are, other than practice, assignments are there which are given by the government. They, this is subject to opinion. I know why you are asking it, Shrest. You have an opinion that it may be violated. There are examples wherein judges are not allowed to take those assignments because they may compromise. And this may have a mark on the independence of judges. At times it does have, at times it may not. So this is very much subject to opinions. But I believe the spirit of separation is present. Spirit of separation is present. That means that in the functioning of their different works, they should be clear what they are doing, in what capacity they are doing. Otherwise, president being part of parliament and president being head of executive are two different things. President is exercising something on the based on the advice of council of ministers, and if there is something which president can do without such advices or is not bound to, this debate will also go on very long. So there will be a lot of opinions. So similarly, this is also very much on the opinion side. I don't disagree with any of them because it is check balances. So one organ will exercise power over the other, but will not be absolute. Means over that organ also, some other organ will exercise some power. So this is how our setup is, say, weaved, and it goes on. Coming to the next slide. The Constitution is given in Article 368, and Article 368 lays down that it can be in the houses of parliament. And the important thing is that there has to be a majority of the members, majority of total membership of the house, and 2/3 of the members present in voting. After both the houses have passed, it goes to the president. President's assent is required, and then the constitution stands amended on that point. This is about Article 360. 24th Amendment amended the marginal note to Article 368. power of the Parliament to amend the Constitution and procedure thereupon. Earlier, it was only the word procedure was used, power was not used, and it was in Goraknath's case where it was pointed out that the marginal note is to be interpreted in such way, it's to be interpreted like it deals only with the procedure, not with the powers. Question arises: if it is not having power, then what about all the earlier amendments? But that was not an issue. Maybe to avoid all those questions or for some other intelligent reason, the doctrine of prospective overruling was also laid down in the same judgment. I'm very sure that you all are aware of these terms and we need not have discussion on that. On one hand, the Golaknath case attacks on the Parliament's power to amend the Constitution, and on the other hand, it tends to justify the amendments already done. Basically, the 17th Amendment was there, which did put a lot of agrarian reforms laws into ninth schedule, and from there the problem started and it went up to this Golaknath case. Question arises: what an amendment can be like, what can be amended and what cannot. Golaknath case talked of the basic structure. There may not be any quantitative restrictions, but there must be some qualitative restrictions on what the uh, Parliament cannot amend, and that basically was the basic structure of the Constitution. They cannot amend it to disrupt the basic structure of the Constitution. Later, it was recognized in the Keshwarananda Bharati versus State of Kerala, and it became a law, the Basic Structure Doctrine. Whether the Basic Structure Doctrine is a limiting doctrine or is an expanding doctrine, means it limits the powers of the Parliament or it emancipates the Parliament to make any amendment. There can be both opinions. On one hand, it does limit, and on the other hand, it does unlimit. It frees it up. It can make any amendment, provided that the basic structure is not touched upon. What is basic structure was not listed. Basic structure was also theoretically defined by the court, in fact, not defined by the court. So, whenever the Supreme Court wants, it can crack the whip. So, it is like you can make any amendment unless we disapprove it. So, you can do anything, but you can't do what we don't want you to do. Kind of. I might have put it in words very informal, but situation is like that only. Because me and I, the Supreme Court, is the only party which will know what is the basic structure. Further to it, something which has been declared as a basic structure, is it possible that the same can be undone? That no, in light of the late development, something which was declared to be a basic structure is no more a basic structure of the Constitution, and now it is beyond that purview. After this, is it possible that a further shift of stand is open? Looking at the trend of Supreme Court judgments, it is very much possible Supreme Court saying one thing in one case, and maybe after some years or after a very long gap, Supreme Court saying something totally different from that. So it is not impossible from that trend, but no feature of the Constitution, which was held to be a basic feature, has so far been reverted from its position of being a basic feature. Further, Supreme Court has nowhere confirmed that it can be done also. Questions on this slide? One more thing which I thought someone will ask for is Article 368, if read thoroughly, the amendment procedure. Someone was saying something. Someone was saying something. You can use the chat box also if you feel like. By the way, if you read it, we'll find that constitutional amendments are to be seen in three categories. First, amendment means any letter of the law is changed. First, if any letter of the law is changed, but it does not have any impact on the very basics of the Constitution, on the core of the Constitution. Second, when it is changed, but it can be changed by the ordinary procedure laid down. Third, when it is changed, but to be done by a very special, thorough procedure. First one is about incidental amendments in the letter of the Constitution. For example, new states created. If a new state is created, the name has to be added. A location in the Rajya Sabha is to be adjusted. For those things also, the letter of the Constitution will be changed. For this, procedure is also simple. It can be done by simple majority of the House. I am very sure we understand it. Article 4 of the Constitution confirms that such incidental amendments shall not be treated as an amendment of the Constitution within the meaning, sense, and ambit of Article 360. So they are not amendment technically, but they are amendment literally. Second thing, if some addition, deletion, variation, etc. is done by way of the procedure given in Article 368, there are two. One is when in both the houses by simple, special, and double majority, and President assents to it. Second is when not only the two houses but also the state assemblies have to pass it. So in that case, and I believe why this Article 3 thing is kept away from this procedure, because it was directly about states reorganization, and states reorganization will fall in the category in which there may be a popular demand that will go to the state ratification part. However, Article 3 makes it clear that state shall receive a reference from the president, shall receive a reference, but there is no mandate that state has to assent to it. State may pass an adverse resolution. Still, the center, the parliament can go ahead reorganizing the state, and that has happened. In many cases, Bihar passed an adverse resolution while making of Jharkhand. Andhra Pradesh made an adverse resolution while making of Telangana. Thorough reading will suggest that first is away from 368, two is normally within 368, and why three? Why this third category? This third category is basically focusing on the federal spirit of the Constitution. The provisions which are listed and subjected to state ratification, those provisions are basically related to the federal features or federal spirit of the Constitution. That means if federalism is going to be affected, in that case, state ratification will be mandatory. This is the thing which makes the amending procedure rigid enough to term it as a federal constitution despite being amended. So the dynamic character of the constitution can be secured despite it being amendable. I believe this is all that I wanted to say. Nobody asked, so I discussed it from my side. Shall we move to the next slide, or do we have questions? No questions?
Why was there a change between power and procedure?
Who asked it?
Rajeshwar.
When did Rajeshwar? Okay, Rajeshwar. Uh, when we use the chat box, I get the name, so and I get it. So I asked. Power and procedure. Question was whether Parliament. I have already spoken on it. Whether Parliament has power or not. I think the beginning of tussle was there. Tussle was in fact not beginning, but tussle was opened up. It was say it could not be any more be kept hidden. If the court does not want the parliament to be able to make a particular amendment, and parliament has made that amendment, how to control it? Basic structure doctrine is an attempt. If it is seen like that, I am not saying what I am saying is absolutely correct, but it is kind of an opinion or a design to see it like the basic structure doctrine is an attempt by the Supreme Court to control the parliament. You can do whatever, you can fly as ever high you want to, but subject to my impositions. Is it not so? If the Supreme Court did not want the Parliament to be able to amend, to make a particular amendment, and it all started basically with the first amendment when the ninth schedule was introduced. Ninth schedule was introduced not with any bad purpose. Nor was Supreme Court bad in saying that it should be open to or whatever. But thing is, okay, there are two different organs. Both are exercising power. Both may have common purpose. At times, both may have common purpose. At times, they may have different purpose. The difference of purpose will be clarified by the examples that I have set in the coming slides. But it was there. Some difference was there. Supreme Court wanted the Parliament not to make it, and Parliament had done it. So, in the Golaknath case, Supreme Court is, I see it a contradiction. On one hand, they are saying that they are not capable of making any amendment. On the other hand, they are justifying all the amendments already made. Rajeshwar, I am sure you understand. This is a contradiction. This contradiction may be explained in a number of ways. Maybe that by saying that whatever is already done, if that is undone, retrospectively that will create so big a complexity that might not be cured. And it will be very difficult to handle the polity. Structure may collapse in. So it was required. But in the same judgment, you are saying they cannot. And immediately after that, the next amendment that was done, which made it power and procedure. And the court did not say anything. Court could have done a lot of it, but court did not do anything. That's the attempt was only to stop that particular thing which the court wanted to turn down. Here, I may not be sounding very clear, so make it further clear. I need to refer to the Wednesbury Doctrine. There is one Wednesbury Doctrine. There was one Wednesbury Corporation case. It's not an Indian case. It's an American case. But it is basically taught in administrative law. You would have studied it. Something which is unreasonable, when the exercise of power is abusive, unreasonable, arbitrary, courts can exercise jurisdictions. This is a tendency in the courts that whenever they see something which is unreasonable, they attack on it. They just have a tendency to frown upon it. And for that, lot of legal logic is given. Maybe that some of the legal logic is so tenable and sustainable that it sets example and creates precedent. And at times, this logic is so temporary as this saying, as this reading of the marginal note. Because in the interpretation of a constitutional provision, marginal note may be important. There is again two opinions on it. The other opinion says that the marginal note is not that high importance, not of any high importance. But in any case, it is to be understood that if the marginal note does not have a mention of power, it lays down the procedure. And in the entire reading of the provision, not only the marginal note, the total provision is read, it is well observed that the power is there with the Parliament. Parliament can do it in this way. So shallow interpretation was generally not expected. That means circumstances would have been somehow special. Just to add value to their legal logic in a particular direction, this was also utilized. I cannot speak more open than this. To strengthen one particular orientation of legal logic, this fact was also added on to it. As a separate fact in isolation, this would not have been sufficiently strong a legal logic to turn down the things that the court did in this judgment. So that was also an additive thing. Implications were big. So that invited an immediate next constitutional amendment. And that next amendment was not questioned. If there is no power, how are you making that amendment? But that was not questioned. That means it was so intermittent, temporary, and intended to get something done which was unsupported in absence of that. Rajeshwar, does it answer? Or the debate is no doubt still open. But does it answer to a fair extent or not? You have all the rights to say no, because this debate can totally closed. The story of the tussle. Now I'm coming on to the beginning of the tussle. The story of the tussle begins with the Kameshwar Singh case. It was about right to property, and a petition was filed before the Patna High Court in 1950, in which the classification which was said was having property more than this, the zamindars who have enjoyed intermediary status. All this classification that was done for, say, acquisition of their property towards agrarian reforms that was questioned on the basis of right to equality. The petition said that this is violation of Article 14, and the Patna High Court held in affirmative. That was in 1950. However, the Kameshwar Singh judgment from the Supreme Court was delivered in 1952. But after the Patna High Court says it in 1950, immediately the state had a feeling that this is going to be a big disruption in the process of agrarian reforms and say in the implementation of the objectives of Article 38, 39, etc. Social justice has so many aspects, and social justice will have such aspects also in which economic interests are involved. Having a landless laborer and an intermediary status, zamindar, a zamindar of intermediary status, maybe enjoying immediately or pre-constitution. But the property is big, the status is not equal. Titles were also attached. If Article 18 is separately to be seen, only titles can be confiscated. But here property is being confiscated, which is something so tangible and protected within the provisions of Part 3rd. So here it was an apprehension. I am not saying, and no author has written, that the Supreme Court had a different intention than what the legislature was trying to do. But court had to come down technically and heavily on those abstract ideas getting implemented, which were primarily in contrast with the provisions of Part 3rd. One may argue that Part 4th was being furthered and Part 3rd was being, say, uh, superseded. So why not the debate of relationship between Part 3rd and Part 4th begin with this case only? This should have, and this could have, but it was not argued in the court, so court did not opine on it. I hope that students are understanding what I am trying to say from this Kameshwar Singh case. Rajeshwar, Shresht, and others, please write a word in the chat box. That could have emerged as a better debate on this point and could have led to, say, earlier closure of the thing. But things were not that simple. So, after this Patna High Court order, immediately a first amendment to the Constitution was made. First amendment has so many things amended in it, but one of the important things was that ninth schedule was added. The insulation of ninth schedule was added. The shield of ninth schedule was included. And the laws kept in the ninth schedule were supposed to be non-judicial review, even if they are clashing with Part 3rd. This is how the agrarian reforms were attempted to be furthered. The same Supreme Court, after so many number of years, has said very clearly, vocally, and say openly that ninth schedule is also not beyond judicial review. The Supreme Court could have said it at that time also. That means intentions were shared, intentions were common. What the legislature was trying to achieve through those agrarian reforms, judiciary was not totally unconvinced with. Question was about how to do it. And howsoever you do it, it was going to come in clash with some of the legal provisions. So on certain points, court had to kept silent. Maybe that you don't agree, but it happened. On the point of acquisition, and on the point of acquisition and then compensation, there were provisions which were made and laid down that executive has not only primacy but total absolute rights in the determination, in the say promulgations related to acquisition of property and in the determination of compensation. There are two cases on it. One is Shankari Prasad's case and the other is Bela Banerjee, Srimati Bela Banerjee's case. In both these cases, court has held that it all comes within judicial review. Courts can intervene. In Bela Banerjee's case, court has written very vocally that the determination of compensation, the grounds on which compensation is being determined, the amount which is finally arrived at are all subject to judicial. The fact of acquisition, the purposes of acquisition, the procedure of acquisition, and notification, taking possession, and other confirmation verifications, benefit being given, everything is subject to judicial review. Question may arise rather than question to discuss who should do it. Question should arise: why should there be a tussle on it? Is it that judiciary has got a personal interest or legislature has got a personal interest? The only difference is that their merits are different. Legislature is a political organ. It has got popular support, so it has to implement the popular voice. If high numbers are demanding something, this is more sociological. High numbers are demanding it. The greater interest of the greatest numbers, greatest good of the greatest numbers, they have to implement it accordingly. But if the greater good is not in fact a greater good, say it's something like slavery, the greater good is not technically qualifying the merits of justice, then what will happen? The popular demand, if not conforming with the ideals of justice, that has to be controlled by the court. This is how the court decides it on the point of substantive merit. So the criteria of determination of right and wrong, which the court follows and which the parliament follows, may vary at times. However, I should not be saying, and no one would accept it, that they are totally different. The deliberative process is supposed to sum to the substantive uh, pointers of merit, substantive pointers of justice. No law can be supposed to be intended to do injustice. Supposed to do justice. Laws tend to define justice. Laws tend to bring about justice. What a person should be doing in a situation which is not yet arisen. But if that situation arises in that particular domain of human conduct, how the person or the institution is to respond, that is law. That is a provision of law. And a provision of law which does not cover any situation which may arise. Whenever that situation arises, law comes incomplete on that. So there is a need for judicial interpretation to expand it so as to cover that situation. Is there any clash between the intentions of legislature and judiciary? But clashes were there. The uh, Golaknath case, particularly in the point which Rajeshwar has asked, that the power and procedure, why two different things? This was too technical. Sure, we agree on this. If this part is done, we'll move ahead. I need at least one confirmation that this slide is done so that I can move ahead. Thank you, Karthikeya. The Golaknath judgment made the tussle visible, undeniably visible. And that discussion we have already done after the question. Now it was time to come to a balance. If the balance was drawn easily, then my point in saying that both had similar intentions, there was no egotisticism, no ego clash, no, uh, urge for supremacy, that point was justified. So whether it got settled immediately or not, that we'll discuss now. The marginal note of Article 368 was amended in the very next amendment. Article 368(3) was inserted. Nothing in Article 13 shall apply to any amendment made under this article. And this all was done in the 24th Amendment. Then came the Keshwan Bharti case, and it was decided what cannot be, not in very tangible terms, not in very clear terms, but theoretically determined the ambit of who will do what, and how the checks and balance will be drawn. It was theoretically laid down, and some boundary was drawn. If it was accepted, if it was really followed, then the tussle was supposed to be over. But one thing is that Keshwan Bharti case leaves open certain things, like what is the basic structure, whether it can be reverted back to a non-structure status, non-basic status or not. Things are open to some extent. And further, if beyond this legislature comes up to do something, that will be marking like it is not only about similar intentions with different methodologies in achieving the same public good. It is something different. And that something different will confirm that there is some tussle, some institutional tussle between the two institutions. We are saying it two because there are three, but two are clubbed. Is it possible that someone can supplement something on this by writing in the chat box, preferably? Any one response will confirm that I am being heard also. No response is creating apprehensions whether we are all involved in the session or I am speaking unilaterally and just monotonously. Ask a question, supplement something, make a comment in the context.
Sir, basic structure doctrine was also showing that the supremacy of the judges only. Then in this case also there was a tussle only that the judges wanted to show their supremacy.
Is it Rajeshwar?
Sir.
So good. Thank you for the response. It showed that there is some tussle, unavoidably visible tussle now. Then comes if it was all over immediately after that, it must have been construed or it could have been construed that there is nothing like egotistic tussle between institutions, and it is same thing being furthered with the same intention by two different parties, so two different opinions. Opinionistic difference may be something different, but real tussle was visible, and it was in the 42nd Amendment that after the Keshwanand Bharti case, there was insertion of Article 368(4) and 368(5). 368(4) says no amendment of this constitution, including the provisions of Part 3rd, made or voting to have been made under this article, whether before or after the 42nd Amendment, shall be called in question in any court of law. 368(5) says for the removal of doubts, it is hereby declared that there shall be no limitation whatever on the constituent powers of Parliament to amend by way of addition, variation, or repeal the provisions of this constitution under this article. That means attempts were still on to gain supremacy by the parliamentary organ. That means tussle is a real tussle. It shows, I am not saying this is my opinion, it appears to any reader that something happens to protect it, a cover is created, after that some further development comes from the court, then some further development from the legislature, then further from the court, now again something has come from the legislature. This was made during emergency. Many a times in our discussion of this kind, we don't include it because it was made during emergency, and that is a part about which we say that this is not the ever occurring legislature executive. It was something different from the routine, but because it had amounted to a constitutional amendment, so it has to be discussed. And here, the amending power was sought to be totally beyond controlled, unfettered. It was Minerva Mill's case which confirmed that this cannot go unfettered, and it held that 368(4) and 368(5) of the Constitution are unconstitutional. The additions made by the 42nd Amendment are unconstitutional. So they are inoperative. Interesting thing is that Supreme Court cannot undo the letter of the Constitution. It can only make it inoperative, so that appears in the bare Constitution with a mention that they are not operative. Sure, we understand. So, which party, if there is a tussle, which party can and which party can be said to be wrong? On this front, we may form an opinion, but on this front, rather than being right or wrong, it may be like both are consistently leading towards finding a perfect balance. And in the process of perfect balance, the two ends shall keep dwindling, leaning in one side for some time and then leaning in the other side for some time. This may be seen as that also. However, the reality of the tussle at this stage cannot be denied. Sure, we are clear on this. And if we can close this particular issue, we can come to another issue. So let's close it. On this specific aspect, starting from Bullocknath, coming to Keshwanand Bharti, the Basic Structure Doctrine, and the 42nd Amendment, and the Minerva Mills case. This is the series of things that has been discussed in the preceding slides. And that was like starting from, I should not be saying he excluded the First Amendment. And before that Kameshwar Singh, then First Amendment, then other cases also included the acquisition and the determination of compensation, but it becomes unavoidable from the 17th Amendment onwards. Then this Gorakhnath case reopens it up all. Then Keshwanand Bharti case, what could have been better in this basic structure doctrine that could have avoided the say uh, boldness of the tussle? If the basic structure doctrine had some mention of certain provisions like these are the basic structure, they cannot be changed, or these are the doctrines application of which cannot be amended, that could have been possibly a better way out to avoid the tussle from getting so intense. I call it intense because after the Keshwan and Bharti case, it should have been over. It was possible. Okay, it was over, but it did not get over because that ensured the supremacy of the judiciary. It gave total powers to the parliament, but ensured the supremacy of the judiciary. And parliament is struggling for that supremacy. This is the tussle which has become unavoidable. This concludes on this point of property rights, and now coming to another point. Whether tussle, supremacy, superiority, that conclusion will do cumulatively towards the end of the session. But one aspect is done. If on that aspect there are questions, we'll be discussing, or we'll move on to the other aspect that we have to take. Questions? Thank you, Rajesh, for the response. Second aspect, thank you, Stesh. Second aspect that we can discuss is a perspective on the reservation policy. It all began with the Champakam case. This also in 1950, wherein it was held that in view of the clear prohibition, express prohibition given in Article 15, Clause 1, there cannot be any caste-based reservation. No caste-based reservation. If the words are to be understood, court was so vehement that caste-based reservation is not at all possible. Immediately after that, First Amendment included addition of 15(4) that adds some enabling provision, to Article 15, saying that nothing in this article shall prevent the state from making any special provisions. The scheduled caste, the scheduled tribes, and any other socially and educationally backward classes of the citizens of India. One thing, can there be any discussion on the constitutional validity of this enabling clause? If fathers of the constitution did not want to have any dilution of the standards of 15(1) and 15(2), they must not have added 15(3). 15(3) is an enabling clause. It does not give any right to anybody, but it gives enablement only to the state, that if the state feels it required, in whatever way required, it can make special provisions for women and children. Nothing in this article shall prevent the state from special provisions for women and children. There is also enabling clause, there is also non-obstante. Non-obstante, the scope of non-obstante character of the provision is within the article. Nothing in this article. If the words would have been like nothing in this part, that was non-obstante to the whole part third. If the words were like nothing in this constitution, then the non-obstante standards were non-obstante to the entire constitution. However, any such non-obstante status does not make it absolute anyways. But by the way, it was only an opinion regarding validity of the non-obstante or the enabling clause status of 15(4). That was fine. First Amendment was done. Thing is, so court interpreting the Constitution, the supreme knower of the Constitution declares something, but that knowledge, that version is to be undone by legislative action. That came in the First Amendment. After that comes the case of Balaji versus State of Mysore. Balaji's case, apart from all other things like socially and educationally other things, Balaji's case has a clear opinion on no caste-based reservation and on the fact that caste and class are two different things. We may have some opinion here also. Like we applied adjustum generis in the interpretation of Article 12 of the Constitution, we may apply it here also. Scheduled caste, there are two specific words, two specific enumerations: scheduled caste, scheduled tribes, and comma. Scheduled castes, comma, scheduled tribes, and the closer of the listing comes with a conjunctive. So it becomes conjunctive. Scheduled caste, scheduled tribes, and any other socially and educationally. That means if there is something common which can be found between the specific enumerations, the same common feature can be imposed on the generic term to delimit its application, and that would be application of adjustum generis in finding out the meaning of the generic term. Sure, you understand it. I have discussed it in my classes also. By that understanding, class and caste are going to be similar, because scheduled caste is caste which is scheduled. Scheduled tribe are also castes which are tribal castes which are scheduled, and any other socially and educationally backward classes. So here, by adjustum generis, caste and class may be seen as similar, but that's an opinion which has been never accepted, or at least not accepted till these judgments by the Supreme Court or any other court. That was the time, Balaji was the time when courts were totally against caste-based reservation. If the judgments are read minutely, the tone in which the judgments are written, they don't seem to be permissive of caste being the determining factor of backwardness. That means caste cannot be the sole criteria of determination of backwardness. Caste cannot be the dominant criteria in the determination of backwardness. Further to it, caste cannot be even one of the relevant criteria in the determination of backwardness. Till this time, Balaji, Chitralekha. After Balaji, there was one more case, Chitralekha versus State. Same tone continued. After that came the case of K.S. Jayashri versus State. Same tone continues. And that was only in the case of Periya Karuppan versus State, wherein the court some acceptance that caste may be at times utilized as one of the factors or indicative of something, but it cannot be the dominant criteria in the determination of backwardness. All these cases being challenged are evidence of legislature having a different opinion and legislature having so many attempts to implement caste-based reservation. Here, I don't have any intention of making clear my opinion. I am only trying to read the opinions of the legislature and of the judiciary. Judiciary is having the stand that no caste-based reservation, class and caste are totally different, and legislature having an opinion that caste and class are either same or similar, are somehow strongly linked up. It continues, and that debate comes to some resolution in the case of KC versus Kumar, wherein the policy of reservation was framed by the state of Karnataka, and the state of Karnataka uh, tried to implement reservation on the basis of caste, and this was challenged. When it was challenged, court issued notices. Court does what? When it is accepted, court issues notice. When the notice was issued and the date for filing counter affidavit was given, the state government did not file any counter affidavit. They submitted to the jurisdiction of the court and sought guidance. This is to the best of our understanding of the Constitution that we have made a policy, and we accept that there may be differences between two opinions. we totally submit to the jurisdiction of the court, and we'll frame the policy, we'll reframe the policy as guided by the honorable. This was a very difficult situation for the court. 5 judges gave separate but concurring judgments. 5 judges bench delivering 5 separate but concurring judgments, no dissent. All of them tried to find out. They have been vocal in saying that caste and class are different. But not only caste, they are different, but caste can be one of the factors, but it cannot be the sole factor. It has to take care of other things also, like the occupation, place of habitat, lifestyle, history of the caste, their uh, other living factors, their earning levels, and all. However, there have been a number of judgments in which courts have said, the courts have held that in the determination of social backwardness, economy cannot be a determinative factor. But in the multiplicity of factors, that was also mentioned. But at the very end of it, court concludes that it is like in our system, the caste classified society used to be in a hierarchical structure. The word hierarchical is not coming from the judgment. I'm only trying to express my understanding of it, so I'm using a different word. It has been so hierarchical in terms of superiority, and caste has been relevant not only in terms of this hierarchy of respect, who is more important, who is more respectable. That has had a complete set of complex factors involved with it, including occupation, what a person will do for his her livelihood, that will also depend on his caste. The caste based occupational guilds have been operational since ages, since generations and generations, and on the basis of that factor only, the place of habitat was also decided. There used to be places where particular caste will live, and all the caste used to live in their own areas, and they used to perform duties like that. So it has to be taken into account. Maybe that caste and class are different things, but in the identification of backwardness, caste is unavoidable. If you want to identify the backward lot, you'll have to use the caste factor. This is what finally was accepted by the court. So in the tussle between the two organs, legislature means including legislature and executive on one side, and on the other side being the judiciary. In this tussle, the legislature side was pro-caste based reservation and the judiciary side was anti-caste based reservations. They have never said that Article 54 is invalid. There was no judgment on it in which court said that this is unconstitutional to be added. So amending power was not here in question. What was in question was the meaning of it. What exactly does it amount to? The amenders did not use the word other socially and educationally backward castes. They used the word class, and court refused to apply adjustum generis in the way as we have just discussed. And they said they are different. But when they were to give the meaning of it in implementable terms, they had to just submit to it that this is in fact possible. That means at times the popular mandate, the popular demand, or the popular opinion may also be right, and the gaps between the popular components, yeah, the democratic factors and the substantive factors of substantive merit of the ideals of justice. Despite there being some gaps, there have to be some fillers, and fillers being emphasized may be seen as harmonization of the two situations, of the two conflicting ends. Possibly, Vasant Kumar is harmonization of that situation. Possibly, but we cannot be so sure about it because there's something further beyond this also. Let's come to that. Do you have any questions on this? Thank you. I should not be saying thank you for no questions because questions are variable, but we can go ahead. Enabling clauses and clashes with general prohibition of Article 15, we have already discussed because it's all in the same series of things. So this bullet point has already been covered. The enabling clause was not under any debate as to its constitutional validity. So the constitutional amendment power or constitutional amendment was nowhere in question. What was in question was the application of the provision. Maybe the amended provision is new added provision or the old one. Now, in spite of the same thing, I'll jump to the Indira Sani case. We all know this. We have read it. From Champakam to Rajan to Indira Sani, the developments also we are aware. We already knew it. We have done some analysis of it by mentioning certain cases and the two parts, the legislature opinion and the judicial opinion, and how it all was going on. Indira Sani case happened when in 1989, the Union of India, the new government, in the leadership of Mr. Vishwanath Pratap Singh, they came up with the sudden thought of implementing the Mandal Commission recommendations. The recommendations made in the leadership of Justice B.P. Mandal could have been slightly different. They had recommended a lot of facilities to be implemented first. All the villages and all the remote areas to be connected with proper transportation facilities, roads, etc. Basic amenities including healthcare, drinking water, sanitation, education, etc. being available. Then access to the amenities be judged, evaluated, empirical data be analyzed, and then decide backwardness, and then it was to be given for the OBC quota. That research was done, but it was done in haste, or maybe howsoever it was done, but it was not so easily accepted by the community. If it is coming from the legislature, that means the majority community, the popular demand is pro policy, but it was not that policy was not so popularly accepted, and the society went into a caste divide, the so-called upper class, lower class. Upper lower are not very suitable words here, but this is how it was generally used. The reserved class, general class. This class was leading to riots and a serious disruption of law and order situation was also happening in them. And a number of petitions were filed, hearing for many of them combined. Supreme Court in Indira Sani case, the first Mandal Commission case, decided on certain points. First thing it says that caste-based reservation is valid, constitutional, and possible within the constitutional scheme of equality as laid down in Article 14, 15, 16. One thing. Society was divided in two parts. One was caste-based reservation, other was not. Court has satisfied one lot. Here I need to have a reference to the doctrine of social engineering, the idea of social engineering, the sociological jurisprudence. I'm sure you are comfortable with that. I'll have brief reference to that. Would it be okay? Kindly encourage me by giving a response. Yes, sir, no, sir, or something, as ever you feel like. Would you be comfortable with that? Thank you. Thank you so much. Encouraged and happy. The utilitarian principle bases on the greatest good of the greatest numbers, but it has nowhere any intentions of causing detriment to the lower numbers. It exactly means that on some front, this particular part of the society or one segment of the society will receive benefits, and on some other front, on some other domain or other walk of life, some other segment of the society will be benefited, and someone will be at loss. And those compromises on the interest are just because of balancing the competing demand or competing interests. So it is about law being an instrument of making a balance between the conflicting interests of the different sections of the society with minimum amount of friction and waste. Here, the society had got divided into different segments having conflicting demands, and friction was high. Supreme Court basically is not supposed to the best of my understanding, courts are not supposed to get into a social engineering exercise. Social engineering exercises are basically to be done at legislative level, where the lawmakers are popular houses, deliberative organs, and representatives of all organs or all sections of the society are present. They can speak on their interests, they can represent it thoroughly, and then, if required, there can be division of votes and a conclusion can be arrived at in a democratic way. judiciary being a non-democratic organ, it lacks totally in democratic character. It should primarily, basically, and largely focus on the substantive ideals of justice rather than going on the balancing of popular interest. The greatest good of greatest numbers. Here is a flaw in the utilitarian ideology that somehow may not be exact empirical numbers, but somehow number count matters. But in the substantive merits of justice, numbers are not at all meritorious. Numbers are meritorious only when the different thoughts, different schools are all appearing reasonable and all are reasonable, and there is to be one and finalized. Then a judgment is arrived at by a majority of 3:2. Even a 4:1 majority would be good. More than that, any application of democracy is not supposed to be in the judicial determination of issues. But here in this Indira Sahni judgment, court is doing social engineering to the best of my understanding. This is less of a justice delivery and more of a social engineering thing. One segment of the society is pleased by saying that caste-based reservations are okay. This is not like I am happy or unhappy with it. I am only analyzing judgment and discussing it in light of the series of cases along with the constitutional provisions. Court says it is valid. So one segment of the society gets happy. Balance is attempted. Primary balance is attempted. Court also goes on saying that the, the clear prohibition, the express prohibition of Article 15(1) on the ground of caste itself is demanding classification on the ground of caste if equality among equals is to demand it. So, in light of this, even in absence of any enabling provision of Article 15(4) or 16(4) or 16(3), there could have been caste-based reservations possible within the meaning, sense, and ambit of 15(1), 16(1). That's great. That means the legislative exercise and the judicial exercise from Champakam Durai Rajan to Indira Sahni, including the First Amendment and so many other amendments and so many judgments, has gone in vain. If I am criticizing it, that does not mean that I have any disrespect for any judgment. Forget about the court to say it, because court is honorable always. This is to analyze it scholarly. Second point, the court says because it is only to implement equality among equals, so to compensate on the generations long age-old backwardness, some affirmative action is provided, which would not be required once the benefit is given, so there shall not be any reservations in promotions. The other section of the society is satisfied. Is it not social engineering? Reservations in promotion were turned down in Indira Sahni's case. Further to it, court says, if there's a point, you can write in the chat box. Further to it, the court says that the benefits being given to some people, the benefit being availed by some people, it may go like the same generations of those beneficiaries will keep getting the benefits, because now they are more resourceful. They are on a superior footing as compared to the other members of their own caste. So they will easily avail it, and the benefit of reservation will get concentrated into certain families only, rather than going to the real needies or the other needies. Therefore, there should be exclusion of the creamy layer. Again, the other party is getting satisfied. Also, the court said that caste-based reservation is okay, but in no case the caste-based reservations can exceed 50% of the total number of seats. Other parties also getting happy. So in all this, repeating the judgment will not be of any high purpose. You all know that. So rather than that, I'll go to the idea that I wanted to present. So here, this is also an idea that this social engineering exercise done by the court in the Indira Sahni case, this is not very much in line with the stand that the court had taken since earlier. KC Vasant Kumar was a submission on the part of the court because court was not able to lay down a different scheme which was not based on caste. So the tussle between legislature and the judiciary on this point regarding implementation of the reservation policy comes to a submission of the judiciary. KC Vasant Kumar marks an appropriate character of the legislature that they are ready to resolve, but judiciary has no alternative, So they have to come down to something convergent. They have to converge on something. But Indira Sahni case is apparently more of something in which court was compelled to enter into social engineering, which is not incorrect, which is not unconstitutional, but that is not sole expectation from the judiciary. However, the conflict is still going on. The reservation in promotions was turned down on the ground that it would only perpetuate the caste system, which we intend to abolish. So a constitutional amendment, 77th Amendment in 1995 was made to make it constitutional, a provision for reservation and promotions. If equality is a basic feature of the Constitution, a specific shape of equality or a specific incident of equality is a basic feature of the Constitution. That incident may have so many complex factors, roots and shoots into it, and all those would be subject to judicial review. And here, judicial reviews have been against it. However, the the legislature has still been adamant on making sure it full-fledgedly applies on caste basis. So, a constitutional amendment was made. Then, because it was held in T. Devdas, that the carry forward rule cannot also exceed 50% quota. Carry forward rule was not turned down. It was that if by application of carry forward rule it exceeds the 50% quota, then it will be not constitutional. Thing is, 50% quota is the upper limit by the court, and legislatures have been standing on that upper limit. Means to the extent I can be permitted, I'll stand there only. There is no provision that it has to be 50% exactly. If it was 49%, that was also fine. If it was 30%, that was also fine. Legislature's opinion is that to be at the maximum possible level of caste-based reservation. Why so? That means there is some tussle. Tussle not in terms of power. Here, tussle is in terms of opinion. The judicial opinion has been one side, legislative on the other side. Perpetuation of the caste could have been of benefit to the political organs, may not have been beneficial to the courts, or courts might not have considered it. Maybe that those are factors. There are so many things herein to exercise. The the creamy layer quota that was given. About the creamy layer quota, the creamy layer exclusion. There can be things like the court did lay it down, but the court did not define it. This is very much contrary to the tendency of the court and very much pro the tendency of the court. Contrary to the point of view that courts have been activist. And in the series of judicial activism exercises, courts have laid down so many things like an authority should be constituted. In the environmental law judgment, you'll see that an authority should be constituted which will take action like so and so. So and so type of person should be its members. But here, court did not go into much details. Court said that identification of the OBCs is the responsibility of the state government. Similarly, exclusion of the members by of creamy layer is also responsibility of the state government. And what the legislatures have done on this point, the immediate responses were like, some states said there is no creamy layer that exists in our state. Some states made it a very high criteria so as to evade exclusion. This is how it was functioning. So the opinion tussle is apparent. Any questions on this? If no questions on this, I'll simply mention a judgment and close. Or that can be mentioned later also. Okay, I'll mention it then at another appropriate time. Next agenda. Am I audible? Thank you. Is about appointment of judges. In the judicial appointments, it has a long history. Maybe that there are a lot of interesting facts, but I'll have to do it little faster because I have to close in time as well. First thing was about appointment of Chief Justice. There are few instances. Once a CJI was not. Tradition was that the senior most judge was made the CJI. once it was not followed. But in that case, there was no hue and cry because that judge was himself not interested because of health issues, and he had given it in writing, so that was never discussed. But it became an issue after the Keshwanand Bharti judgment. When the Keshwanand Bharti judgment was decided, there are a lot of things which I think I don't feel shy in sharing with students, because there is a lot of literature available on it, which is available in public domain. It was a judgment delivered by 7 is to 6 majority. 7 is to 6, 13 judges went deciding it on it by 7 is to 6 majority. It delimits, it restricts the power of the legislature, and the power of the judiciary was held like superior. So it was anti-government. In this, the, the people who were prominent most in the 7 judges majority side, which held it against the government, those were the senior ones. And their seniority was not respected while appointing the Chief Justice of India. Justice Shila, Justice Grover, Justice Hegde, it is written everywhere. They were the senior most and they were superseded. And the next to them was Justice Ray, who is, many people say, I'm no witness to it, but at many places it is written also that he was the prominent judge, most prominent judge in the 6 judges minority category. Many people have also, I heard it in some lecture, and I remember I read it also somewhere, that he was cousin brother of Mr. Siddharth Shankar, leader of the ruling party. Maybe that it was based on that, maybe that based on opinions, maybe otherwise. But those seniorities were disrespected and they resigned in protest within 24 hours. From here started the debate whether executive is having a free hand in appointment of Chief Justice or not. Cases were also filed, but since they had resigned already, so the remedy was not possible. The matters, the petitions were infructuous. Second instance comes during emergency when ADM Jabalpur versus Shivakant Shukla, the habeas corpus case was decided by 4 is to 1 majority. 4 is to 1 majority. Only one judge in this full bench was writing it against the judgment. It says it is our diamond like rock hard belief that the government will never misuse this authority. That was about suspension of fundamental rights during emergency. Justice H.R. Khanna was the dissenting judge who wrote that Article 20 and Article 21 can never be suspended even during emergency within Article 359. They cannot be suspended. And that became a law after the 44th Amendment, when it was written by amendment in the Constitution. So in this way, there can be seen some amicable incidents also in the history of judiciary versus legislature. Legislature is making those amendments what judiciary had held in minority. The development of law being contributed by both the organs. This is a very good example of it. But when it happened, the ADM Jabalpur case was decided, and the person who wrote against the government was senior most, and he was to be the CJI, and his seniority was violated. He resigned in protest. The next judge was Justice Beg. I never read anything about him that could have been the preferred choice for person for this or that. Never read anything or heard anything on that. But seniority was violated and he resigned. Petition was filed, but petition became infructuous because he had resigned and resignation was accepted. Tussle was open. Here the tussle was directly with the executive. But because we have combined executive and legislature both, so tussle is relevant to our purpose also. Committed versus independent judiciary. If it is to be seen, these two instances particularly, lot of discussion is done and lot of literature is available on whether judiciary should be committed or independent. Judiciary, no doubt, should be independent. It cannot be committed, means committed to the executive or the legislature. And the question asked by Shresh Srivastav, that post-retirement assignment, that may create elements of commitment. And this is why it is many a times argued that in some polity it is like the judges don't retire. They can continue working till the time they want to. Very old judges are also there in American Supreme Court. They are physically fit, so they are continuing. And whenever they take retirement, they are not eligible for any assignment. That could be a great practice. But in our country, the problem is about faith in institutions. There are very few institutions in which popular faith is still existing. there is judiciary, there is at times military. So whenever you don't have any faith in any institution, to some extent CBI, you demand what? CBI inquiry. Because you have faith in CBI that justice can come out, facts can come out, justice may be possible if CBI makes an inquiry. Similarly, judicial inquiry, a judicial investigation, judicial inquiry, a judicial intervention that can lead to. So some assignment, so judicial inquiry, maybe by a sitting judge, maybe by a retired judge. So if the retired judge is given that assignment, that will be something kind of a situation which Shresh Srivastava has pointed out. So it can never be denied that judiciary may be committed. Any organ, any person may get committed. That's human. To be wrong, to err is human. But that being in that being realized, that having been there in high frequencies, that is a mark on the social culture and the standards of morality. So in this clash, the judiciary side was towards independence, and the legislative pull was towards making them committed, as the examples may justify. After this, there have been cases. The judges transfer case gives primacy to the executive in the appointment of judges, but the 21st Law Commission report criticized it, vehemently criticized it, and the Supreme Court Advocate on Record Association versus Union of India held that it has to be the senior most judge who will be the CJI. This tradition has to continue, and that will be binding on the president also. Appointment by the president after this judgment becomes a formality for the CJI. And for the appointment of other judges, it gives primacy to CJI. CJI will recommend, and that person will be appointed as a judge in the higher judiciary. CJI plus the senior most judges. This is how it forms a collegium. Here from it comes. So the two parties, the executive's power is restricted by the judiciary because it is appointment of judiciary. So they say judges will appoint judges. Question arises: what if the judiciary becomes corrupt? That was in 1999. The next judge's case, the Supreme Court Advocate on Records Association versus Union of India, in which a better balance was maintained. That was the time when Justice Punchi was the Chief Justice of India. Collegium had recommended certain names about which the reports, there are different type of reports which are gathered after the names are recommended to the executive. The LIU reports. Reports were indicating something not very positive or something which could be objected. So the executive at that time, Prime Minister of India was Mr. Bajpayee. Executive refused. And President means the Council of Ministers, made an advice of Council of Ministers. So that was refused. After that, it went to court, and the court itself held a very good example of judicial or self-restraint by the judiciary. Judiciary said that executive is not compelled by a mere recommendation by the collegium or by the Chief Justice of India. Both the organs have their separate, independent, autonomous mark and role in the appointment of judges. Very much like within the collegium also, it is recommended that if judges dissent, Chief Justice must not insist. However, the Chief Justice is capable to appoint it, but he must not appoint because the majority will be in favor of that party, two judges plus CJI, but he must not. That means by 100% vote, by consensus is the preferred thing. So why not to include executive also within that consensus? They also have a right to dissent. In this case, it was held that executive is not compelled to appoint after recommendation by the CJI. However, a rider was still secured by the judiciary despite exercising also self-restraint, that in case it is once again recommended, refused, but immediately recommended again by the collegium, then executive has no chance than to appoint it. And this has seen application also in appointment of some Supreme Court judges. I'm sure you would have seen those instances. Justice Joseph Kurian was the Supreme Court judge appointed by second recommendation. After this comes the Njc Act, in which question was that the judges should be appointed only by judges, and there are a lot of questions on it, lot of questions on accountability. So the Njc Act was made, and huge arguments were given, but the act was turned down by the Supreme Court, having been termed as unconstitutional. That means judiciary has retained the whip. In most cases, despite all restraint having been exercised, they have retained the whip in their own hand. And when it comes to appointment of judges, this is it's a burning example that they have retained the whip. I'm not saying that NJC was the better option. If my opinion is to be considered, I don't think NJC is going to be a better option. I would not like to elaborate on it because of paucity of time. So we'll come on to that different. The removal of judges is a restraint by legislature. Question mark. Since we talk a lot about self-restraint exercised by the judiciary, but is it not that legislature has also exercised restraint? I am not concluding. I am only proposing. The removal of judges is possible under Article 124 in the legislative houses. And it is possible that a judge who is not going by the choice of the government can, by normal, say, skullduggery, operate something towards removal of the judges. But that has never happened. Despite there have been cases in which some judges' procedure for removal was placed, but that could not gain majority sufficient in numbers to remove the judge. Further to it, there have been cases in which a judge's removal process was on and petitions were filed by the members of parliament to get a stay on it. This may be seen as a restraint, self-restraint by legislature in not going to such far an extent that faith in the institution is totally abolished. Means legislature has also had some role in maintaining faith of the institution. But at the same time, if all those things are, all those facts are cumulatively understood, there will be a question: is it a balance or an excess? For this, I leave it all open to you to gather your own facts, and if we are to discuss it further, that will be a totally separate discussion, because that will not be on the point of tussle between judiciary and legislature, with no concern on the point of amendment. But that's also a topic in constitution to decide. Up to this, if there is a question, please ask, or I'll move further. No questions? So we'll now take up the pre-UPES debacle. Many a times I apprehend that I am not being heard. Am I audible? Are we on the right track, or we are going monotonous and boring? Here, no answers will definitely mean that it's going boring. But not much of time is left. We have tolerated a lot. About say 20-25 minutes more. I'll try to wind it up fast. About the pre-UPES debacle, it is said that there was something in the minds of Mrs. Gandhi. She wanted to abolish the pre-UPES. There are many very strong justifications. By reading some literature somewhere, we should not form opinion. We refer to literature, but that should not be the sole mark in forming of an opinion. It is said Mrs. Gandhi had a different opinion that pre-UPES should not be released. So she placed a bill for abolition of it. Because it was there in the constitution provision, so amendment was required. It was proposed, but the bill failed in Rajya Sabha. It could not be done, but because you know which prime minister it was, that was a presidential proclamation at that time. It was promulgated in the form of an ordinance that now these things stand amended and there shall be no pre-UPES released. Then there was a petition filed by Mata Rao Scindia, who was one of the beneficiaries of the pre-UPES, one of the uh, earlier pencil state ruler, filed a petition, and judgment was there in their favor because there is a constitutional provision, because there was a bill which failed in the parliamentary house, and there is then a promulgation. So that would not suffice. There has to be either a proper, thorough, authorized alteration amendment in the constitution, or you'll have to release the pre-UPES. To nullify it, there was some amendment made in the constitution which was possible, which was passed by the houses. And then it was dropped. Privy purse was not released. That was 26th Amendment, and this 26th Amendment was not challenged as well. It makes amendment in certain articles of the Constitution, and Article 291 and 362 were amended, and Article 368A was added, which is to the effect that privy purse stands abolished. So this amendment also has some tussle because bill proposed legislative process fails, then promulgation, the Supreme Court says something and court's judgment was. So is relevant here in this case. Questions you can ask. This is about latent loss of right to education. Very less discussed in this existing context that we are discussing. Less talked of right to education. So I like this topic, and I always say that there was a constitutional amendment to add something, add a fundamental right. Still, I am saying that here the legislature and courts have had different opinions, and the tussle of opinion, not tussle of power, but tussle of opinion is here. Even the privy purse case can be linked up with the tussle of power, but here I'm saying it only as a tussle of opinion. There was an opinion in one judgment, which I don't have right now with me, that a right to information has certain dimensions which link up with right to education. In absence of information, knowledge, understanding, education, etc., you cannot form an opinion. An expression which does not get proper backing of information and knowledge and education, that is of no meaning. So Article 19 would include right to education. That judgment is very less mentioned, not in all constitutional law books. I read it once and then I did not get the citations. Immediately after that, I missed the name, and after that, I did not get it. Article 21, you know it famous in Mohini Jain, in Unni Krishnan. It was held as right to education as a fundamental right. Are we going right? Is it audible? Once a constitutional amendment has been made, it's not so easy to call it a breach of constitutional obligation, because amendment was done with full majority, proper majority as required, and that amendment was not challenged. If it is a breach of constitutional obligation, only Supreme Court has an authority to say that, and that too when it was litigious. The litigating parties in Mother India's case, the Privy Purse case, they did not go on challenging that constitutional amendment. So that would not be easy. But we can always point it out as a tussle, because Supreme Court judgment was nullified by an amendment. So this is the opinion that I can give here. The rest, Mohini Jain says that right to education is a fundamental right from 6 to 14 years. Article 46 has some references to right to education, and that may be linked up to 6 years, but that does not restrict right to education to that. Definitely. Mohini Jain says 6 to 14 years fundamental right to education. Unni Krishnan says right to education is a fundamental right even beyond 14 years of age. Please mind here. Please mind me saying that Unni Krishnan says right to education is a fundamental right even after 14 years age. But up to 14 years is a fundamental right implementable through writs. But beyond that, it is subject to resources available in the state. That means it is a fundamental right, but it is still a directive principle. That's true. So what is the meaning of this beyond 14 years wala fundamental right? It has got some meaning to my understanding. When the constitution began, right to education was not at all a fundamental right, and reason simply being lack of resources. And when in 1990 Supreme Court is saying that it is a fundamental right till 14 years of age, that means Supreme Court is declaring that state has resources to limit it till that level. State is not declaring. State is running away from it. Supreme Court is declaring. In Unni Krishnan's case, Supreme Court is saying that beyond 14 years, it is subject to the resources of the state. That means it is very much possible that in the next 10 to 15 years, Supreme Court could have said that now those resources are also available, and now it is an obligation over the state, is a fundamental right implementable through writs even beyond this. Krishnan says that up to the level of higher education, professional education, technical education, it's all fundamental right. But beyond 14 years, it is subject to resources with the state. So it was very much possible that the series of cases suggesting Mohini Jain to Unni Krishnan only 1 year gap. It was possible that after a gap of 10, 12 years, there was going to be another judgment which said that up to higher levels it is a fundamental right. And that would have been a very difficult position by the government. Sure, you understand. 86th Amendment came in 2002. That means after Unni Krishnan, 10 years had got completed. 11 years was going to be completed when it was made. That means government was just apprehending. This is my theory that I say government was apprehending that any time a judgment of this kind can come, which is going to fall heavily on the government because that will invite so many number of writ petitions which the Supreme Court will not decide favorably for the government, and it will be difficult. So it is an apprehensive exercise of power that 86th Amendment and the RTE Act were made, and the Unni Krishnan and the prospects beyond were all nullified, restricting the fundamental right to education only to 6 to 14 years. Here, the relation between directive principles and fundamental rights also need to be discussed. We have already discussed the importance of Minerva Mills case, that after Keshwan and Bharti case, when the legislature was not ready to accept the restriction imposed by the Basic Structure Doctrine, they attempted by way of the amending powers, which was not uh, accepted by the Supreme Court, and Minerva Mills cases is a final authority on that, declaring unconstitutional the subclauses 4 and 5 of 4 and 5 of Article 368. Herein, the series of cases would be like coming from Mohammad Hanif Qureshi to other cases, to Champakam Dorairajan, to this Minerva Mills, up to Minerva Mills. Which one is superior? When the directive principles were being, when the constitution was being written, I just need one confirmation. Are we going on the right track? Is it that the class is interested? Is it that we as a group are interested in, or I can conclude very fast? On this particular issue of the tussle of opinion, Prachi, thank you so much that at least one person responded to it. On this particular topic, there can be very lengthy discussion, and the other side should also respond for that, that there is no tussle of opinion. In fact, I see there a tussle of opinion. Tussle of opinion because when the constitution was being framed, at that time, what the rest of the world was doing. Just imagine, because India having got independence and sovereign status, and then the demand that India had made in the early 40s, even before the Cripps mission had come, Indians were saying, the Indian leaders were saying, we'll make our constitution by our choice, free from the British influence, because we apprehend your influence will have some intrusion into our constitution. They did not want. And Britishers were imposing a condition that you first make your constitution, so that according to the provisions of your constitution, will transfer power from British Crown to your Indian institutions. Cripps mission failed, one for this reason, second for the say demand for separate Pakistan, Muslim League, for other reasons. They were saying it cabinet mission was an acceptance that you will make constitution after having got free from our control. We'll release it, and the power will be transferred from British Crown to the Constituent Assembly, which will dissolve after the constitution is made and constitutional institutions are established, and interim government will be formed. That was all agreed. That means influence being received. We wrote our constitution by receiving so many inspirations from different parts of the globe, and the rest of the world was at that time busy in writing instruments of human rights. The United Nations General Assembly was sitting every day to work towards fulfilling one of the two basic objectives for which United Nations was formed. One was international peace and tranquility, about which General Assembly had limitations. Second was protection, preservation, and implementation of human rights, about which General Assembly, being the deliberative organ, had bigger play, and it was deliberative. For certain reasons, there could not be any convention or a binding agreement on it, but they came up with a Universal Declaration of Human Rights, which does not make any classification between the economic, social, cultural rights and the civil, political rights. The same trend is followed by our constitution in the writings of part third. I feel there is some similarity in it. The debate between first generation and second generation human rights was finally brought to a balance that is not about first generation and second generation. We should list out the very important fundamental rights, and they should be implemented in two ways. First, which all can be implemented immediately, and rest which all need resources. They should wait. They should wait does not mean that those rights are of secondary status. They should wait means they are of the equal status, but we have no other choice than to wait till gathering of resources. And right to education was one among them. I am very sure that majority will agree with me. But the legislature has not come up with any scheme, any efforts visible, or any declarations that now we have come up to so and so state, so we'll do it. Rather, they were busy in what? Affirmative action and making it taking it in a different direction. So popular government, populistic government, welfare government, all those things, all those elements can be evaluated how far in implementation. So the relation between directive principles and fundamental rights has also seen some balance or some say difference of thought or tussle of opinion on this point. But the balance was finally harmonized by the doctrine of harmonious construction, which finally came out in the Minerva Mills case. So I close this particular slide here. If there are questions, you can ask, or we'll take up the next slide. So presuming that there are no questions on the earlier slide, it's about legislative process and the judicial interventions. First thing again comes up from the affirmative action part. Enabling clauses and implementation of benefits. Enabling clauses were not challenged and courts have not contested it. If courts were vehement opinion that are attributed to courts and the other part of it having been attributed to the legislature, if courts were so adamant, they could have come up with different judgments by saying this is not at all possible. There is no limitation on the court for not taking any suo motu action. 54 was never challenged. Sorry, 54 was never frowned upon, never attacked. Court accepted. Means court was exercising self-restraint. In the legislative process further, the enabling clause was enabling clause. If courts were to make it clear, they made it clear. There was a case, Gulshan Prakash, there is a case, not very old case. Gulshan Prakash versus State of Haryana, decided in 2010. Court says, and before this also there are many judgments which say that this enabling clause does not mean that it creates a right for the beneficiary to be. There's no right to get reservation. It is the state which is to decide whether reservation is required or not. They are enabled means they are enabled to do something which otherwise than that provision they might not have been able to do. They can do it. This is in the legislative process. Courts have stayed away from intervening unnecessarily. Legislative privileges, accountability of the House members, and the role of courts have been another issue in which there have been so many issues kind of tussle between legislature and judiciary. However, it does not have essentially something to do with the amending power of the parliament. In this, the most important part is Article 105 and the P.V. Narasimha Rao case. In the P.V. Narasimha Rao case, it was in 1994. There was a no confidence motion which was brought about in the House of People by the leader of the opposition, Mr. L.K. Advani. And in that, by the calculations which I remember given in the media, the government was in danger. Later, it was found that few members had voted after having received gratification from the ruling party. Prevention of Corruption Act was to apply, but when it was contested that by the provisions of Article 105, the parliamentary privileges, they are not accountable to any authority other than the House itself. That means House could have taken action, but House will not take action because they are standing with the majority side. If House takes action, then the majority side will go to minority. And here is the clear difference between the democratic merit and the substantive judicial merit. This is what I keep pointing out on many occasions. This is clear difference. This judgment was in favor of parliamentary press. It was Chief Justice's bench at that time which declared that they are immune to any judicial proceedings, not action, immune to any judicial proceedings by virtue of the parliamentary privileges contained in Article 105 of the Constitution. This judgment was criticized, severely criticized, and after that the judicial stand changed. And we all know what happened in Kalyan Singh versus Uttar Pradesh, and we also know how interventions increased in the Jharkhand Assembly case. So, and we also know the instances wherein the speaker's actions were questioned, and at times speakers lashed out on the process of the court. I remember well-known advocates and speaker like Mr. Somnath Chatterjee once had given a public statement that courts should remain within their limits because he was the acting speaker at that time. Nowadays, there are clear examples like in Karnataka. Speaker has to take action. Court cannot take that action which is due on the part of the speaker. But speaker has to take action. Whatever action you can take, you have to take. Court will not act on your behalf. There is no limitation on it when on these issues courts have come up with activist stands, which can be related to the tussle studies between the different power organs. However, these may not be linked up directly by the tussle things, but there are some instances through which we can link it up. So this aspect I'm going to close. If any questions are there, you may ask. No questions presuming, I am coming to the conclusion part of it. The last slide is here, which will conclude this discussion. It may appear that I have been focusing or I have been leaning in favor of the court because the collection of facts could have been like that. However, it is not like. Thing is, the spirit of separation is present. It was in A.R. Antule versus R.S. Nayak, wherein the Supreme Court has said that separation of powers may not be mechanically, tangibly through provisions present in the constitutional structure, but the spirit of separation is involved therein. Judicial activism has had its profits, and there have been certain losses also. There may be certain losses also. The loss may be that judicial activism is a certificate that other organs are not working, but there are a lot of profits. If judiciary stays away from intervening into legislative action or to review the executive action, that will create problems also, because there cannot be any final absolute answer that democratic merit is correct or free from flaws, or judicial merit is free from flaws, because judicial merit will come from a lot of theories, and those theories, when they come to application, may have certain dimensions in which opinions may vary, both opinions being correct. So judicial merit also sees application of democratic merit in the finalization of the judgment. Judgments are delivered by majority. DC Badwa versus State of Bihar is an example wherein the checks and balances was considered to be of real application. The legislative process by executive power, in means promulgation of ordinances, that was being misused. Court has used a term there, fraud on constitution, and court seriously frowned upon those actions. Serious actions were taken, and when all those accounts were opened, when details were opened, it was found how much of loss to the state exchequer was being done, how much of arbitrary exercise of power was being done. So that means legislature and judiciary both have to have that checks and balances. And in a setup of checks and balances, no organ can sit above the other, because the organ which has check over the other organ will also have check over itself to some other organ. The basic structure doctrine imposes limitations on the parliament's power to amend the constitution. But the basic structure doctrine only theoretically gives the whip in the hands of the judiciary. Judiciary, having misused that whip, is not having such big examples which can be cited. So here, the power balance is more visible than the tussle. Judiciary should exercise effective self-restraint. I believe legislature has also exercised self-restraint. I have given two examples. One, when the legislature had given like a this enabling clauses were not interfered, and one more when the removal of judges thing, and one more example I have given. Legislature can also be seen as exercising self-restraint. Judiciary can be seen exercising self-restraint on a number of occasions. So the way judiciary retains the whip in its own hand, judiciary at the same time also exercises self-restraint. Now coming to whether there should be something like hierarchical structure or separation, I don't think there is any requirement of it. And any organ, because it is led by humans, so there shall be certain examples where they exceed the bounds. A clear example of this is visible in the judgment of Sarala Mutkal versus Union of India. In that judgment, the justice had issued certain orders. Those orders, if they were correct, court must have come up with a contempt procedure when the executive says we are not going to obey it. And if that is incorrect, then in the further judgment, judiciary must not have explained it. In the next case, just 2 years after that Sarla Mutkal judgment, that was Lily Thomas versus Union of India, in which the court has written, in the judgment it is written that the earlier judgment of Sarla Mutkal, these parts were in obiter. So there would be very less rare examples in which a judgment explains an earlier judgment saying that this was an obiter. So I see it very defensive writing by the courts. That means it's an admission of a mistake. At times, courts also, because they are human beings, they may go on writing certain things which are not that legally, technically sound, but they correct it. Similarly, legislatures and executives may at times go on, maybe in the rush of the moment or in the rush of some welfare spirit, they can do something which may not be tenable in the eye of the judicial merit. So that can be changed. It should not always be seen as a tussle. Now, the last point is lawmaking an exclusive legislative domain. This is a topic in itself. I simply say that lawmaking is not, I'm directly jumping onto the conclusion that it is not totally a legislative domain. It has to be contributed by legislature and also by the judiciary. Legislature means inclusive of executive, because executive contribution is no doubt there. Formation of the bill, if it is a treasury bill, if it definitely comes from the government, that is the executive. Judiciary has got huge roles and at times crucial roles to play in the lawmaking process by the process of interpretation. It is not that in Article 12 the word other authorities was not known to the makers of the constitution that this is vague and this will need explanation. Still they made it. I see it not as interpretation. I see it not as a general term being used by the makers of the constitution. I see it as an invitation by the constitution makers to the judiciary to come and do the lawmaking beyond this. We have made the law to this extent. The rest of it, you'll do it according to the need of the time and situation. This is how the judicial departments and the legislative departments both have to contribute to the lawmaking. Similarly, law means constitutional amendments inclusive here for the purposes of this. So if the legislative organ has a responsibility, power, authority towards making of the amendments, the judicial organs also have their role to play. And that will be the real balance drawn. If there are questions, please feel free to ask. Could basic structure doctrine had been made retrospective because some crucial amendments were made before the doctrine's emergence. Before this, if that was to be given retrospective, before this, actually, the basis of this entire hangama was this Golaknath case. More than Keshwanand Bharti, it was Golaknath case. And in the Golaknath case, doctrine of prospective overruling was propounded. That means it, on one hand, restricts the power of the parliament to make amendments in the part third, but on the other hand, it accepts the amendments already made by the parliament in part third. This is so. So if the basic structure doctrine was to be given retrospective operation, they must have spoken about this, because in the Keshwan Bharti case, one of the issues was that whether the Golaknath case was rightly decided, whether the Golaknath case was rightly decided. If this was an issue, then that means they must have been conscious that such a thing is also to be closed. And if the basic structure doctrine intended to go retrospective, they must have spoken on turning down the doctrine of prospective overruling, which is not done. So, Shikhar, I think this judgment had no such intention. And further to it, if this is not done, had it been retrospective, then a lot of changes, covered, uncovered, within this, legitimacy cover, illegitimacy cover, would have been effectuated. So, if this is not done retrospective, all those amendments are separately challengeable. They can be reviewed. So, applying it retrospective is not that good a solution as we may just think of the surface like. So, it would be no better idea. So, I am not in favor of retrospectively applying the basic structure doctrine. Hope you agree. Any other questions? If not, then thanks to you. Thanks a lot for being very nice audience to me.
Thank you, sir. Thank you, Ashish, sir. Thank you so much for agreeing to uh, devote a 2-hour time from your schedule with us, this academic cause. And sir, believe me, from as far as I'm concerned, from a clear law point of view, I have studied the law only for 5 years, and the thing which the students takes it from perspective is that we understood this tussle only from one or two perspective, whether be it amending power relating to Part 3 or through the judicial appointments. But sir, you brought many perspective from which we can study this, from reservation to right to education to legislative administration and to everything. So it was indeed very informative. I really enjoyed. Or sometime again, sir, we can have a lecture or a discussion on this where we can discuss this tussle from the state perspective. Because sir, in today morning itself there was a news where the chief minister is writing a letter to the CGI that your second in command is affecting the administration of justice in my state. So this is also something politically towards. So if you have a comment, you can comment on that as of now, or we can have a separate discussion.
Definitely, that should, I would suggest that should be discussed in light of the uh, federal applications in our political structure, because right now the debate is about that federal structure. It's multi-party, single party, uh, integration of the command or centralization of the command or what. So all these things are linked up, and more than beyond that, the aspects that I have attached, all of them are separate lecture topics. So we can have separate lectures on them also, as and when
And
suitable.
so
Just
we were
please speak.
yes, sir. We were also thinking after we formulated these 15, 16 themes that Ashutosh sir and we were discussing that we left out the reservation and we can have to schedule some extra lecture. But today you sir beautifully covered that aspect, and I think
Not
we
fully,
need
not fully.
yeah we need not to schedule any
Some
lecture on the reservation. Fine. So thank you so much, sir. Thank you once again, and I hope that society will get your insight in future as well. Thank you so much, sir.
Thank you, Gautam. Thank you so much. Thanks to all the students. Thanks to Ashutosh sir.
Have a good day, good evening, students. We will meet next week for a different set of lectures. Hope to see you all. Have a good day.